Thank you, Madam Chair, members of the board. CLF respectfully requests that the board dismiss Invenergy's application and close the docket. At every turn in this docket, Invenergy has failed to provide enough information to fairly assess the 1,000-megawatt fossil fuel-fired power plant it seeks license to pave a forest to build. Nowhere is this failure clearer than when viewed through the lens of the incomplete advisory opinions that have been issued by 6 of the agencies and subdivisions ordered by the board to assess the proposed plant. Through this lens, it becomes clear that, as a matter of law, by failing to provide adequate information, Invenergy has violated the board's rules, the board's preliminary order, and therefore the Energy Facility Citing Act itself. The appropriate remedy for these violations is dismissal. 6 of the 12 advisory opinions speak plainly to their own incompleteness and pin that incompleteness on Invenergy. These opinions' language is quoted in CLF's brief and need not be belabored here. Invenergy's failure to provide the agencies with adequate information violates EFSB Rule 1.12b. That rule provides that, quote, parties shall have the obligation to present all relevant testimony and evidence and to fully participate in designated agency proceedings held pursuant to a preliminary decision of the board. Likewise, Invenergy's failure to provide the agencies with adequate information violates the EFSB's preliminary order. That order provides that, quote, the applicant shall provide information in a timely manner, end quote, and, quote, shall remain responsible for ensuring that the information provided to the board and the various agencies remains consistent and up to date, end quote. Invenergy's violation of Rule 1.12b and the board's preliminary order is plain from the very text of the agency's incomplete advisory opinions. Though I promise not to belabor the quotes from those opinions, I will provide an example. The Burrillville Zoning Board pointed to, quote, the lack of information provided to us by Invenergy, end quote, and concluded that, quote, we cannot adequately evaluate this project and provide the EFSB with reasoned judgment as to the effect of this facility upon our community, end quote. The Energy Facility Citing Act provides that, quote, failure to comply with any promulgated board rule, regulation, requirement, or procedure for the licensing of energy facilities shall constitute grounds for suspension or dismissal. That's at Rhode Island General Laws 4298-16A. The board has already found once that Invenergy failed to comply with Rule 1.6 and accordingly suspended the docket. That suspension provided Invenergy with the, quote, reasonable opportunity to remedy the lack of compliance, end quote, that the Act calls for. But as CLF's supplemental filing explains, many of the pervasive failures identified by the agencies remain unremedied. If suspension was the appropriate remedy before, dismissal is now. Invenergy has several responses to this. First, Invenergy suggests that it has provided voluminous information. This argument is nothing more than an attempt to hide the ball. Neither CLF nor anyone else disputes that Invenergy has produced a lot of information in this document. But according to 6 agencies, Invenergy has omitted necessary information, which thereby deprive these agencies and the board of the ability to do their jobs under the Act. Invenergy also suggests that it can remedy its record gaps by supplementing the record as its plans develop. To support this argument, Invenergy points to task orders issued by the board, Manchester Street, Rhode Island Invenergy, and Narragansett Electric Company transmission line improvement project. But from a careful review of these task orders, it doesn't appear that any of the agencies in these proceedings expressed the view that the applicant in those proceedings was withholding information, as, say, the Burrillville Planning Board did here when it observed on page 9 of its incomplete advisory opinion that, quote, many of the data responses we received from Invenergy were incomplete and at times evasive, end quote. Nor does it appear that any of the facilities in those task orders, addressed by those task orders, were ever subject to a motion to dismiss. Sua sponte dismissal by the board in any of those past dockets would have been not only shocking absent the motion to dismiss, but likely appealable error. Here, the board has before it two motions to dismiss, founded on a statute that expressly permits dismissal. That is a deeply relevant distinction that Invenergy divided over in its filings to the board. Finally, Invenergy makes much of CLF's characterization of the 6 incomplete advisory opinions, while failing to address those opinions in completeness. A careful reading of Invenergy's objection to the original CLF motion at pages 6 through 18 actually undercuts Invenergy's argument. Take, for example, Invenergy's brief at page 8, beginning at line 6, which says, quote, CLF is again wrong in its assertion that the zoning board offered, quote, no opinion, end quote, to the board on the questions requested after a review of the available information filed by Invenergy, end quote. Then, turn to the zoning board's advisory opinion at page 11, paragraph 4. You'll find the following quote. Chairman Cloutier made a motion to render a negative advisory opinion upon Invenergy's application for a special use permit as required by the town's ordinance for failure of Invenergy to provide sufficient information for the members to know what they are even asked to vote upon. The motion passed unanimously. In fact, Invenergy's last argument turns out to be mostly a regurgitation of its first argument, that Invenergy provided a lot of information in the docket and to the various agencies tasked with preparing advisory opinions. What the argument leaves out is the question of whether Invenergy provided the information necessary for the agencies to do their jobs. The agencies themselves answered that question with a resounding no. Given this failure, especially in light of the extensive opportunity to cure that the board has already given Invenergy, dismissal is the appropriate remedy under the Energy Facility Citing Act, General Laws 4298 and 16. And I would add that based on what we've received from the agencies in the past, their incomplete advisory opinions, their statements about inadequate information and their inability to offer opinions, the prospect of going forward with supplemental advisory opinions seems like a misguided use of valuable state resources. But one last issue remains. Invenergy's failure to provide adequate information in this document has not just undermined the agency's and the board's abilities to assess the substance of Invenergy's proposal, it has also led to a core legal violation of the procedures set forth in the Energy Facility Citing Act. Specifically, the board cannot possibly convene the final hearing on Invenergy's application within 45 days after the final date for submission of advisory opinions, as set forth in the board's preliminary order, because that deadline has already come and gone, even if one discounts the 90-day period the docket was suspended, as the rules suggest the board can. The schedule set forth in the Act is a, quote, requirement or procedure for the licensing of energy facilities, end quote, under the Act. Failure to comply with the schedule is therefore grounds for dismissal as a matter of law. It has been 15 months since Invenergy filed its application, 10 months since the board issued its preliminary order, 4 months since 6 or 12 agencies said they didn't have enough information to offer opinions on crucial elements of the charges given by the board. This docket has been tainted all the way by inadequate and incomplete information. As a matter of law, the board has been deprived of the considered agency opinions it needs to carry out its duties under the Energy Facility Citing Act, and the Act's deadlines cannot be met. Invenergy has been given every opportunity to come into compliance, but has not risen to the occasion. Under these circumstances, the Act, the organic statute that governs this board and all of its proceedings, calls for dismissal. CLF therefore respectfully requests that the board dismiss Invenergy's application to close the docket.
Mr. Green, are you suggesting that the time period in the Act are mandatory?
We acknowledge as much in our supplemental filing. The time periods are directory. What I am suggesting is that they are procedures, requirements or procedures under the Act that, under General Laws 42 and 9816A, are appropriate grounds for this board to dismiss the application in the event that they are violated by the applicant, which we argue they have been here.
Madam Chair, may I ask Mr. Green one question? In reading over your motion, I was looking through the energy facility spending act rules. And Rule 1.15A6 allows the board to go back to the beginning of a statutory time period after suspension. So I wanted to just get your take on that and how that might affect your argument about your final argument about the time period.
Yes, I did review that rule, and I would have caution in relying upon that rule. It seems to me inconsistent with the language of the Act itself. I would also note that in Invenergy's response to our supplemental filing, they point to the Ocean State Power past order of the board as an exemplar of how the rules and the Act allow for flexibility in dealing with deadlines under the Act. But the very language they quote says that the board, in the circumstances of that case, was, quote, compelled to suspend hearings on various occasions to comply with the statutory 60-day hearing limit. How that reads to me and to CLF is that while the limits in the Act may be directory rather than mandatory, and while the board has some flexibility in how it deals with the deadlines under the Act, for the board to feel compelled to suspend proceedings in order to comply with the time limits under the Act means that there is some strength to the language of those time limits. And what I would suggest would have been a way to possibly cure the violations that occurred in this is for additional suspensions to have occurred, giving rise to an appropriate time period for the deadlines to be told. I'm not being terribly clear, but I think that you understand that.